Thanks for watching the video. You can go to www.lawbarcoach.com for more information or to book a one-on-one tutoring appointment. Part 4 now, we're going to go over contract interpretation. At this point, we've covered the basics of forming a contract, putting one together, a meeting of the minds, an agreement, legally enforceable, those concepts. So right now, we actually have a contract that's been formed between parties. That was their intention. There is an agreement, but how does a court interpret the words of that contract? As much as the parties might like, it's just plain impossible to detail every single contingency, to fully explain. There quite often are going to be terms that might have appeared to be clear at the time of making the contract, but they now look ambiguous because of new facts that have come to light or peculiarities of the parties themselves. They knew what they meant, or they might have intended one thing, but looking at the words as a judge or a layperson, we might think something completely different. The goal of contract interpretation for the courts is to identify the meaning that was actually agreed to by the parties. The courts are not in the business of coming up with new meanings, creating new contracts. They want to simply preserve what was intended at the time. You shouldn't have to be on the hook for something that you did not intend. And as we said, there's reliability is an aspect of contracts. So the more accurately and the more consistently that courts can review and interpret contracts, the more reliable they are, because the parties can have some idea how a court will view that contract. Now remember, with 99% of contracts, you never have to go to court. The parties make an agreement, they go ahead and do it because it's mutually beneficial. We don't assume that people are out to screw each other. A contracts dispute, as a lawyer, that's what you're concerned about, only arises if we're in court. So there's some sort of disagreement, or somebody's done something wrong. And in that situation, the court has to take the contract and figure out what it means. Otherwise, how can they resolve the dispute? For instance, if two people make a contract to mow a certain lawn, and now they argue about which lawn was meant to be mowed. One person says it was lawn A, the other person says, no, I wanted you to mow lawn B. Well, let's say it this way. The lawnmower says, I thought you wanted me to mow the front lawn. The beneficiary, the promisee, says, no, I wanted you to mow the backyard. That's what I meant by lawn. What does lawn mean? Well, the court has to go and figure out what the parties would have agreed to at the time when they made the contract, right? But sometimes that's hard. What if they did mean two different things? What if the person said, oh, I know, I wanted my backyard mowed. That is exactly what I wanted. If you could look at my head, I wanted the backyard. But the lawn mowing company says, if you looked in our head or my head, I would have thought that it was the front yard. There was a disagreement, but we thought we agreed. This is the type of dispute that might occur. Now, does a court get rid of that contract entirely? Does the court attach a new meaning to an ambiguous term? Those are the types of questions that we're going to ask and answer in this section. But if you look here, we say from the perspective of the parties at the time the contract was formed. When we say the perspective of the parties, the reality is you can never go into someone else's head. The only evidence you have of what's going on in their mind is their words, what they're saying to you, and their actions. So based on the words and actions, what is the most reasonable assumption? If someone made a contract to sell a car, and later on the person says, oh, by car I actually meant boat. In my head I meant boat. So when I wrote the word car, I thought boat. Well, from any reasonable person's perspective, when someone writes down car, they don't mean boat. So you can rely on that. You don't have to be screwed over because someone had something very odd going on in their head. It doesn't matter. So whenever there's an ambiguity, there are two options. The courts will not enforce the contract since there was no meaning that was agreed to. If in the case of the lawn, one person thought front yard, the other person thought backyard, if they had two different complete expectations, then was there really an agreement? Or, like I was saying earlier, the courts can determine a meaning that was agreed to by the parties. The courts can say, we're going to rule that lawn means front yard. And, well, why? The court might say, in the industry, when you say lawn, that's the default. 10 other times, these two people have made a contract, and when they said lawn, they were both referring to the front lawn. Maybe the person mowed the front lawn and got a thumbs up as he was doing it from the homeowner, and that there's a lot of different reasons why a court might do that. Here are some methods of interpretation. Now, so I was just saying, well, why would how does a court attach a meaning to a word? You take a look at a word, and where do you get its meaning from? Well, what's the most obvious one? The plain meaning, the dictionary. You can, if a word, the idea is this: parties know that words have definitions. So if they use that word, they need to beware that the most accepted definition is the most accepted meaning of the word. So if you're using words, you necessarily are bound by certain plain meanings. Just like I was saying, if you write down car, but you really thought boat, that is a no-go because the word car has an established meaning and the word boat has an established meaning, and they are two different things. But obviously that's not always foolproof. What does chicken mean? Now that was in a case where they had to decide what the word chicken meant in a contract. You can look up different definitions, but they're slightly different. This isn't a case of a difference between a chicken and a duck. It's between different types of chicken. The plain words don't help us there. So we need to look at other circumstances that would have affected how the parties would have viewed that term. One thing is to look at the entire contract as a whole. Maybe, for sake of argument, if there are two types of chicken, an East Coast chicken and a West Coast chicken, and everything in the contract talked about sending ship transportation to the East Coast, well, then maybe when they wrote chicken, they meant East Coast chicken because there's evidence in other parts of the contract. Now, we said that when parties use words, they necessarily have to understand that the plain meaning is the trump card. And they also have to understand that everything else in the contract is a trump card. But what if that still doesn't get you where you want to go? You have to look at the course of conduct of the parties. Because it's very telling. If they actually started to perform on the contract and did it a certain way, that helps guide what they were actually thinking at the time. Then we look to past dealings between those parties. If that's how they actually deal with each other, then that's probably what they meant when they wrote this contract. And then there's usages within the trade itself. Maybe chicken or car or lawn or whatever, when used in that context in the trade, has a certain meaning that should have been expected by the parties. Now, obviously, a consideration is whether the parties were schooled in that trade or that custom and had reason to know what that meant. If we're selling chicken between two merchants in the chicken trade, they probably know what those terms mean. But if I decide to buy chicken wholesale for a barbecue I'm throwing, there's no reason to think that I know industry terms related to chicken, and so that would not be imputed on me. Parol Evidence rule. This rule is technically a rule of evidence, but it's so related to contracts and how you successfully argue a contract dispute and ultimately how you arrive at a contract's meaning. Here, the rule determines whether or not evidence is allowed of prior agreements that are not in the contract itself. Now, take the example between two people. They've written out a contract between each other. And now we're in court. And one of the parties says, oh, well, before we wrote this contract out, there were some other agreements that we had with each other that should also be included in the contract. We have certain terms and conditions that we mentioned speaking to each other, but we never put them into writing. The law likes when things are put into writing. We allow you to make oral contracts in order to speed things up, but if you decide to put your agreement into a written form, into a contract, we respect that far more than any incidental oral evidence. So the question is whether a written contract contains all of the terms that are part of the agreement, or are there agreements outside of the contract that may be proven by oral evidence. As I was saying, this is a question of evidence for the judge. This is his role as a gatekeeper. This is not something that you present to the jury and ask them to decide if they think it's parole evidence. The judge decides whether or not that this can be admitted at all in order to prove the meaning of a contract. The notion here is that we're actually excluding evidence from ever coming to court in the first place. So here's the rule. Let's assume that I have a piece of evidence. I'm going to talk about a conversation I had a week earlier about some term that I wanted included in the contract. It's a contract, let's say, for to wash my car, and a week earlier we said that the car washer would promise to use a certain type of washer fluid, let's say. But when we wrote the contract out, we never wrote that in there as a required term. So, should that be considered part of the contract, even though it wasn't written in it? So, here we go. Prior terms are not included in a final and complete agreement if they are inconsistent or if the writing appears to be complete. Okay, so let's break that down and take the example, like I was saying, we have a prior oral agreement that a certain type of washer fluid would be used. Well, let's take a look. Is it inconsistent with anything in the contract? Let's say the contract was silent on washer fluid. If that were the case, would it be allowed in as evidence? If the contract was silent, it's not inconsistent. It's consistent. So we can bring it in. But if in the contract we specified a different type of washer fluid, then it's inconsistent. The idea is that the writing trumps anything that is inconsistent. The writing trumps. Is the writing complete? Now, this is a tough question to answer. If the contract says the words in this document are the only terms in the contract, then the writing is complete. The writing actually says, don't look anywhere else. Everything is contained within this writing. That's a merger clause. If there's a merger clause, then the writing's complete. Even if a prior term is consistent, it's out. Because the writing says no. Anything else, gone. We're only concerned with what is actually written in the contract. So you look at two things. First of all, is it complete? For example, is there a merger clause? Second, is it consistent? If the writing is not complete and it's consistent, then it can be admissible. But it's not just if there's a merger clause. We'll get to this actually in 1 second on integration. Let me just mention real quick the Scrivener's error. I put it slightly out of order, but this is worth mentioning. This is when the parties change a writing because there was some sort of accident or mistake in actually writing the contract out. Theoretically, they're putting in potentially inconsistent prior agreements, but this is allowed because it's vindicating what they actually intended to do. If they catch an error, it's obvious, they quickly do it, that's fine. The Parol evidence is now that there's a contract dispute, one party saying, oh no, the contract should have concluded something else, the other party's disagreeing with that. So we said that in order for Parol evidence to be admitted, it has to be consistent. Meaning it cannot be inconsistent in the writing. Well, see, this is why it gets so confusing. A prior term is not included in a final and complete agreement if it is inconsistent and the writing appears to be complete. So if the writing is complete or the prior term is inconsistent, it's out. So consistency is easy to identify, right? It contradicts. But how is a writing complete? We said a writing is complete if there is a merger clause. That's one way, by actually explicitly stating that this writing contains the final and complete agreement. Or there can be integration. Now, integration essentially means we're integrating all of our possible agreements into a writing. So there can be no parole evidence because none of that is part of this agreement. Complete integration means the entire contract, as stated in the writing, is our agreement. There's nothing else that we said to each other that we want to be part of the contract. The writing is the final version of the entire agreement, which is essentially a merger clause. Everything is integrated. There's complete integration. Partial integration is if a given term is integrated. Just like we said, if the contract stated the type of washer fluid that had to be used, well, that term is integrated because the contract is complete on that. But what if a contract is silent? They say they never specified the washer fluid. Does that automatically mean we can bring in parole evidence? Well, this is where you get complicated. There are certain tests to determine whether or not a writing on its face appears to be complete. So if we read the contract, it's absent on washer fluid, but we still say, well, this contract looks like it contains everything. It would have mentioned the washer fluid if that was important. So parole evidence is not permitted. If there was going to be a washer fluid requirement, it clearly would have been in the document. Since it's not, parole evidence isn't admitted. So let's look at the tests. One test is, sure, show any parole evidence you want. Any relevant evidence is admissible. Another here, to a reasonable person, does the writing appear to be complete? Or would the writing have naturally contained? So, would the contract naturally have specified the type of washer fluid? Let's say the contract was specifying a lot of other types of minutia requirements, other types of fluid, other types of... Well, they probably would have put washer fluid in there if they wanted a certain washer fluid, right? But these are just different ways of looking at it. One is, would it naturally have been in there, or would it have certainly been in there? And that's what the UCC uses. These are very narrow differences. Again, one is saying, would a term naturally have been included in the writing, or would it certainly, would it must have been, does it have to have been in there? Exceptions to the parole evidence rule, if it wasn't complicated enough. Even if something appears to be integrated or the prior statement is inconsistent and therefore you can't bring it in, you're still allowed to talk about extrinsic evidence of oral agreements in these circumstances, if it relates to fraud, duress, mistake, public policy, lack of consideration and capacity. So if you're saying someone did something bad and I need to tell you about prior agreement that we were going to make, you can bring that in for those purposes, but not to change the meaning of the contract though, but to prove this stuff. A prior condition is allowed. It is not subject to parole evidence. The idea is that the condition is determining when the contract comes into effect. If we write a contract out and we say to each other, oh, unless the temperature gets above 90 degrees, this contract is void. We never write anything about the 90 degrees in the contract. We go to court. I tell the judge I have parole evidence I would like to submit about an agreement regarding a condition that this contract would not go into effect unless the temperature was above 90 degrees. That is permitted because it is a condition. Parole evidence is also allowed if we're trying to prove the meaning of a certain word or term. Now we're not adding a term that was agreed beforehand. We're clarifying the meaning of a term that is in the contract. So, in summary, here's the idea. If you put something into a writing, that's the default contract. Prior oral agreements are only permitted if they are consistent and the contract isn't otherwise integrated or complete regarding that term or the contract as a whole. Promises and conditions. We said before that a contract is a legally enforceable promise or a legally binding promise. I promise to wash your car, you promise to pay me $50. We're making an exchange of promises, one in consideration for the other. The result of that is a legally binding contract. But what is a condition? A condition states when a duty to perform a promise goes into effect or goes out of effect. We'll get into an example of that in a second, but here's an interesting distinction between promises and conditions. Promises must be substantially performed. If I promise to wash your car for $50, I've made a promise to do something for you, and in return you're paying me $50. Now look at the language here. You're agreeing to do something, you're promising, you're saying I shall do something. That's word of a promise. Let's say I do a very good job of washing the car, but it's not perfect. I've substantially performed. You can sue me for damages, but the contract is still on. I've done a very good job. Conditions, on the other hand, must be fully completed. The idea is that until that condition is met, the duty to perform does not mature. Now let's look at the language. If the car is 100% clean, you will pay me $50. Here's the language. Provided that, unless, if, when, upon which, after which time. So look, if the car is 100, and we can even write, then you will pay me $50, or you won't pay me $50. So if the car is 90% clean, no go. It must be fully completed. But this is an odd one. A court might even view this as actually being a promise, because why? This is a hard standard to meet. We want substantial performance. We want parties to give it their best efforts. If somehow they can't be perfect, then we let damages sort things out on the margin. But a condition is very brutal. You do 99% of a job, you get $0. That would be very oppressive. So, what's a better example of a condition? if it is 90 degrees, you will wash my car. So this is your condition. If it is 90 degrees outside, you will wash my car. If it's 89 degrees, you're not washing a car. This duty to perform only matures when 90 is hit. Anything beneath that doesn't matter. There's no such thing as substantial performance here. So just like we were saying, conditions are more oppressive than promises. As a result, courts prefer promises over conditions. And one other thing to mention is that there's an implied duty of good faith regarding the occurrence of a condition, because oftentimes a condition might be one of the parties' actions or conduct might influence when a condition arises or occurs. So if a party needs to get a certain kind of permit, let's say, before someone else then can come onto their property to build something, there's an implied duty to act in good faith to get that permit. You can't sit on your hands and never get the permit on purpose and say, well, the condition never occurred. You can't do that. The types of conditions. Conditions precedent. If it occurs, then there's a duty to perform. A condition subsequent, the duty to perform ends when the condition occurs. Here's an example. John promises to wash the car any Saturday when the temperature is above 70 degrees, but he shall not have to wash the car if it's raining. So what is his duty to perform? What is the promise? Washing a car. The condition precedent, what's the language here? When. He promises to wash the car any Saturday when the temperature is above 70 degrees. If it's 69 degrees, there's no car washing. Once it's 71 and above, so above 70, then this duty matures. He now has to wash the car. Shall not if. But he shall not have to wash the car if it is raining. Here's the condition subsequent, raining. Let's say it hits 71 degrees, he starts to wash the car, and then it begins raining. It extinguishes the duty to wash the car. Implied and constructive conditions. These are what we've talked about here, above 70 degrees, raining, and so forth. Those are explicit, they're expressed, they're written directly into the contract. But there are certain implied conditions and constructive conditions that a court will read in when it's otherwise not stated. One of them is the condition on willingness to accept. If we make a contract where I'm going to deliver corn to you on Tuesday and I show up and you have a moat around your farm, you can't then tell me that I didn't come through, that I didn't deliver the corn, because my duty to deliver the corn is conditioned on you having a willingness to accept. If you put up a moat, then I no longer have a duty to actually to deliver it, because you don't have a willingness to accept. Again, we've said already that there's a condition of good faith read into every contract, and there's a condition on performance, and then you will pay. What does this mean? Unless otherwise stated, if I promise, say, to wash your car, then you pay me $50, there's an implied condition that I have to first do that thing, and then you pay. It just makes sense. It would make no sense, unless we otherwise state it, of course. It would make no sense for a court to think that the payment would come first and then the performance second.